please the court. Daniel Stoddard for appellant John Coleman. This appeal presents two issues under the Freedom of Information Act, or FOIA. The first being the fee category challenge, the second being the fee waiver denial issue. And the court below and the DEA on appeal have advanced four erroneous arguments as to why the district court did not have to even reach the merits of those fee issues. The first is the argument that that Mr. Coleman had a duty to prepay when there were disputed facts raised in the administrative appeal in order to get judicial review. The second issue was that the case was controlled by Pollock. The third was that Mr. Coleman had to do an appeal, a second appeal, after the court case had already been filed in order to advance his fee waiver issue. And the fourth issue was that there was no an argument raised only on appeal that no constructive exhaustion is even allowed after an administrative remand. And he still doesn't have any of the requested documents? That's correct. They never reached the fee issues never were reached, and therefore there's a complete impasse even at this very basic stage. The prepayment of fees essentially shut down the request. Let me start by saying that prepayment of fees is not required when there is a direct challenge to the basis for that fee assessment. Here, where the commercial request was incorrectly assigned to Mr. Coleman, and he presented an administrative appeal to the DOJ saying why he was in the wrong fee category. And the DOJ agreed with him, and they remanded it back to the DEA.
And they sat on it. And
they sat on it, and he constructively exhausted. And so for that reason, this case is not at all like Pollock, where this court suggested you should advance your administrative remedies. Here he did his administrative remedies, and the DEA just did not do a determination on the fee category. The problem with this prepay, if you think about it, is it completely blocks judicial review of fee issues. Because what if the agency were to say $1 million is due or no judicial review? They say that, and what are you going to do? If you don't have $1 million, you cannot go to court. That's not the rule. The rule is you have to constructively exhaust, number one, and you have to present the issue, number two. He did both of those things. If the agency had the power to say, well, let's make it $1 billion, $1 billion prepay or no judicial review.
He objected to being thrown in the commercial category, claiming he was a non-commercial use. And the difference between the two is search and copying versus review, search and copying.
Exactly. That's correct, Your Honor. It's the other category. They call it the other fee category.
Right. So the DOJ or the agency said the search alone would cost $1,700 and X dollars, $35, whatever it was. And that was not a non-disputed amount, wasn't it, at that point?
The point is that in order for Mr. Coleman to determine if he wanted to go forward, he needed to know the full ticket price. In other words...
Well, they couldn't tell him. They said in the letter they couldn't tell him.
Right.
And they just said that we have a search cost of $1,734 or whatever it was, $5. Now, he didn't pay that, did he?
He did not.
And shouldn't he have paid that to go forward?
No, because in effect, he had the right to be fully knowledgeable about which fee category he was in, and he knew that the fee category...
So they come and they say he's in non-commercial. Actually, they send it back, don't they?
They remand it back, and the DEA does not do a determination. If to follow up on your question, if they had said, you are in this particular fee category, and he did not have any other issues administratively about the fee...
I may be misunderstanding your case, but I thought your case was not that the agency was necessarily wrong on whether he was a commercial or a non-commercial requester or what have you. But it was simply the extraordinary length of time it took him to get any answer of any kind at all stages of the proceeding.
Well, Your Honor, that is what gives us the constructive exhaustion, but to cut one step further, it's the fact that there was no determination made as to whether that fee category decision was correct or incorrect. In other words, you have no record from the district court saying he should have been commercial.
They never told him what the decision was or what the reasons were.
No. In fact, FOIA is supposed to be a two-stop process. You got a request, and you go from there to an appeal, and then judicial review. This whole business of remand is actually something that shouldn't even be happening, because if you look at the time frames, you've got 20 working days from the request, 20
This is the problem I have, that you have a time frame which is set out in the statute, and it's section 552A6A.
Correct.
And it says do something within 20 days, and here they delay processing of the request for a year and 4 months. And they're told by statute to do something within 20 days. Now, there are exceptions to that. They can plead unusual circumstances, or they can point to the volume of records requested and say we can't give you an answer 20 days because it's such a large number of requests. We need more time. But they didn't do that. As I understand it, I may be wrong, and if I am, correct me. I didn't think that the agency pleaded the exceptional circumstances exception, and I didn't think that they invoked any kind of exceptions to FOIA, like it was sensitive personnel information, or that it was sensitive classified information, or it was a trade secret, or whatever. He just didn't hear anything.
Well, that's right. And first of all, the unusual circumstances only buys you 20 more working days.
I understand that.
And the exceptional circumstances can only be given by a district court, and it was not given.
Right, but but they didn't invoke the unusual circumstances.
That's true,
that would have taken them to 40 days.
That's right.
But the problem here is that as I understand it, there was a delay in the processing of the request for a year and 4 months.
Well, that's right.
Now, it may be that the agency's ultimate decision was correct. It may not be, but the point is the man's entitled to something more than just total silence. I may misapprehend the case, but that's what troubles me about it.
Well, Your Honor, what he's entitled to is that the district court should have determined the fee category issue. That what the beauty of constructive exhaustion is, when the agency sits on it, the court gets to decide the issue, and the agency has blown its opportunity because it missed a deadline.
Well, let me ask you, the district court agrees with you that it is non-commercial. What happens? At
that point, and of course there is the fee waiver issue that has to be resolved. But assuming
that's where I was going to lead initially. Yes. That's a totally new issue.
Well,
that was, the regulation requires you to set forth with reasonable specificity all the justifications for it, and the arguments throughout this were commercial, non-commercial until very late in the game. When you wanted a waiver. And it seems to me on that issue, there has been no appeal to the agency. There was no exhaustion and so forth. I was trying to stick with the commercial versus non-commercial, and so the district court says, you're right, it's non-commercial. In that case, you would have to advance the $1,640. Is that what you would say?
Assuming that the fee waiver issue was not reached by this court, but I will say it was raised on appeal at the JA at 39, the joint appendix at 41. You'll see that it was raised, and the question is, was it raised well enough? But it's not a situation where the district court should not have reached the issue. It was raised. And then if you look at Exhibit H, which is came in after the the DEA was allowed to do a decision document in November after the case was filed, and then if that's allowed, then Mr. Coleman should certainly be allowed to respond to that.
There's something wrong with this. We're all wrapped around the axle. There's something troubling. Maybe the agency can explain it as to why there is this incredible delay, because you have statutory provision after statutory provision after statutory provision saying do this within 20 days. If you don't, the remedies will be constructively exhausted. And here, years and years afterwards, even when the agency admits that there's a problem, he still doesn't have the paper. I can't believe that Congress wants to go through, that Congress wanted a requester to go through all this. And it's not the fact that the agency was necessarily wrong in their classification that troubles me. It's just the delay, in addition to the 1 year and 4 months it took him to get an answer under a statute which requires 20 days. Then he takes the appeal up to OIP, and they delay processing the request or doing anything for 7 months. And then they say, oh, the agency was in error, and so they remand after 7 months. So then he resubmits his initial records request to DEA after the remand, after several years. It was still not acted upon. He submitted it in April of 2010. Nobody acted upon until in August, out of desperation or exhaustion or whatever, August 19th, he files this lawsuit in the Eastern District. And then on September 29th, the DEA finally gets around to doing something after the March remand. And if there hadn't been a lawsuit filed, they probably wouldn't have gotten around it then. But at each stage, the initial response and the appeal and the remand, it's delay after delay after delay. They're not, if a citizen doesn't have a right to have this kind of basic information from his government, whether it be a positive reaction to his request or a negative reaction to a request, maybe the agency's right. Maybe the proper fee should have been $1,748, but why have to go through all this litigation to get there? That is my frustration here.
Well, Your Honor, if I just briefly may respond, I see my time is up, is that Congress did decide that when you miss the deadline, then the district court should be there to determine the issue presented. In this case, the issue presented was the commercial category and the public interest fee waiver secondarily. And really, the district court should not have ducked the issue. They said there was failure to exhaust, but there was the most exhaustive exhaustion that, as you described, and there was raising of the issue. So what more in Pollock have you asked? And therefore, what the district court should have done is just squarely addressed
well, it says
the issue.
In Section 552A4B says, on complaint, the district court has jurisdiction to enjoin the agency from withholding agency records and to order the production of any agency records improperly withheld from the complainant.
And separate jurisdiction to do fee dispute resolution is also in the.
I gather what you're saying is then the built-in remedies for delay, and I gather the agency probably has a lot of good answers. So, I mean, they don't have the personnel, they got a backlog, and when you're searching billions of documents in the government, whatever it is, it's understandably very difficult. But what Congress has built in for delay is access to the court.
Exactly.
And so your argument basically is the district court should have addressed some of these issues.
Squarely addressed.
Whether it is commercial, non-commercial, or whether it's how much to pay in advance or a total waiver. Now, the total waiver is a little more interesting issue. There, I'm not as clear about.
Well, I hope on rebuttal I can further address that issue, unless Your Honors will I guess my time has run, so I would like to reserve some time.
Thank you. Let's hear from Mr. Marks.
Thank you, Your Honors.
They sent you down to protect this process.
They did. Good morning. May it please the Court. David Moskowitz on behalf of the Drug Enforcement Administration. I'd like to first address Judge Wilkinson's issues with the delay, and I'm not here to defend the delay. The agency was wrong, and they have an obligation to do that. But ultimately, before there actually ever was a complaint filed, which he had a right to do 20 days after not receiving an answer, they did provide a response. And that response found that based on the size of the request, it was going to be a lengthy search process, and they asked for him to pay $1,640 of the $1,785 in search fees that they estimated, and they were permitted to do so.
Why didn't you say that earlier? I mean, that there was just, you've got to, I'm not sure how complicated this is, but, and I keep thinking I must be missing something. I must be wrong in the way that I'm looking at this. And I want you to tell me, because I can't believe that my simplistic view of it is actually correct, which is that the statute requires a response within, which says determine within 20 days after the receipt whether to comply with such request, and shall immediately notify the person making such request of such determination and the reasons therefore. In other words, you could have said, we can't get to this right away, or we can't do it because there's a statutory exemption, it's classified, it's sensitive personnel, it deals with this or that, or trade secrets, or whatever, the whole list of exemptions. But just tell the man something. I mean, just he waits a year and 4 months, and then he waits 7 months, and he's on appeal, and then he waits another long period of time after the remand until finally he files a suit, and even then, nothing seems to get resolved. Judge Niemeyer's right that the statute gives the district court authority, as I understand it, to order production of the records if the agency's messed up. And I mean, this can't be with this can't be what Congress wanted. I must be missing something, because if I'm not, it's a bit of a horror show.
I agree here that it is, the agency should have responded earlier. They should have responded, no doubt, well before a year that it took them. But ultimately, they did respond, and this is no different than the Pollock case, where again they took a year, and they were wrong in Pollock, and they were wrong here, but ultimately,
but timeliness is everything. If you're trying to get some records, the reason you might want them is stale, or competitors may outdistance you, or whatever. I mean, there are people out there who are serious researchers that need this kind of thing, and the timeliness is important if you've got an important project.
I agree, but ultimately they have the right, 20 days later, if there is no response, to bring a suit immediately in court if timeliness is of the essence. That is what they're allowed to do. If you wait for a decision by the agency, then you are stuck with what the agency says. And even if you could go to the court for the 20 days,
but you can't fault the man for trying. We put so much emphasis on exhaustion, and you're saying you're going to fault him for not filing suit immediately?
I'm not faulting him for not filing suit immediately. I'm saying if it is, timeliness is something that really matters to him, he has the right to file suit 20 days later, immediately, to go forward with this. But even if he had done so, that still doesn't mean that he doesn't have to pay the fees for the search. And that's ultimately what's at issue here, because the search is an incredibly broad search for basically any correspondence about this particular petition. So why
did you tell him that it was you denied the request, but it was an incredibly broad search?
I believe we did tell him many times. And when my office got involved, I will say, we tried to work with him.
Which is your office?
The United States Attorney's Office in Alexandria. When we got involved, we did try to work with him to narrow the search. And this predates me. I am unfortunately very new to the office, so I don't know anything specifically other than speaking with colleagues. But they did try to work with him to narrow the search in a way that would lower the costs and would lower the time.
When did you communicate that to him?
I believe in the record there were multiple phone calls with him, and then he wrote letters in October and November of 20.
Was that when was that? After when was the first of those? After February 29th, 2008.
Right. Well, so this is all after he filed the complaint, and it's pretty close right after. I'm talking
about, was there any correspondence beforehand? Because it would be nice too if one could work these things out without having to go to a federal district court.
I agree with that, and in fact, in the appeal, which took longer than it should have, no doubt, but they did specifically request that if the fee amount was too high and that he wanted to work with DEA to narrow the search, they suggested specifically that he contact and call the office, and I don't believe that he ever did that. And so I completely agree with you that there should be ways to work this out, but ultimately, there's never been a narrowing of the request in a way that would lower the search fees. The search fees are the only fees that the agency has ever...
All right, tell me where exactly the suggestion was that he narrow the request.
Sure. So it's...
what day?
What day?
What day?
Well, it would be between September and October of 2010, after filing the suit. And also, there's specifically language in the...
All right, so in other words, this whole idea of narrowing the request, the 1 year and 4 months passed without telling him to narrow the request. The 7 months during the appeal passed without telling him to narrow the request. The 6 months or so on remand passed without telling him to narrow the request. So there wasn't any back and forth at all between the agency. They were not trying to be helpful at any stage. You haven't pointed to any administrative correspondence prior to the suit that told him to narrow the request.
Well, so I did point to the appeal from the Office of Information Policy, which is JA40, where it says that told him specifically to contact the DE directly if he was willing to accept less than a complete processing, i.e. to narrow the request in a way that would come up with what he wanted most importantly, and to, for example, some of this correspondence over 16 years, if he was willing to get rid of some of that, it would make the request be processed much quicker, much cheaper, but he didn't avail himself of the opportunity there.
And when was that letter sent?
Sure, that letter was sent on March 29th, 2010. And so, yes, it took a long time I no doubt agree that it took way too long for the agency to respond. There are, many excuses, but ultimately Congress has given the agency the responsibility to respond in 20 days, and they didn't meet that. But when they did respond, ultimately they were within their right to seek the fees. They asked for him to only forward $1,640, the part of the search fee, to process his request. He never did that. He never said he was willing to do that. He always said he was only willing to pay $1,000 total. And under the DOJ regulations, which have been upheld...
So he has a right to contest those fees, does he not?
Well, but he's not actually contesting those fees. He's contesting review fees that the agency has never actually asked him to pay, and has never put a dollar amount. It's never been an issue in this case.
Well, the point is the district court can put an end to this.
Well, I'm not sure that that's actually true, because ultimately his status...
You say that's not true?
Well, because ultimately his status as a commercial requester or a non-commercial requester doesn't seem to matter here, because he's not willing to pay the fees for the search. If he were willing to pay the fees for the search, then we would be much further along in the process. And that's kind of where we're stuck here.
I thought he was arguing he didn't have to pay anything.
Well, so that's a
This was in the
separate,
public
that's,
interest.
so that's the separate issue. And that is an issue on the public interest waiver. And that's the only issue that we're actually arguing he failed to exhaust. And in that, that's because he never presented that request once to the agency. And it is true that you may waive or that there might be constructive exhaustion as to what you have presented to the agency, but what you have not presented to the agency is not constructively exhausted. And so had he put that in his request anytime, before filing suit, and
552A4A 7 or 8, which says an agency shall not assess search fees, or in the case of a non-commercial request, a duplication fees, if the agency fails to comply with any time limit in this statute, if no unusual or exceptional circumstances apply to the processing of the request.
So I believe there you're actually referring to a new section that was added by Congress partially to address this issue that they've not actually asked for that to apply. But it wouldn't apply here because that was added and did not become effective until after these requests were made.
You're doing one, this isn't retroactive. I think you're losing the forest for the trees here. You're trying to, instead of making it easier and simpler and making there be a communication between the government and a citizen who's making a request, you're tying the whole thing in knots through delays and through these all sorts of questions which may demand all sorts of further litigation even at this stage about whether they're going to be search fees charged or whether you're going to be limited to duplication fees, and then there's a question of whether he's in the public interest or not, and all of this should have been sorted out a long time ago.
I agree. It should have been sorted out a long time ago, but it's not only the agency's fault. He has an obligation to present his request with specificity. He never presented his request for a public interest waiver until December 6, 2010.
That part of it is fine. You keep wanting to bleed into the merits. The point is, he was met with total silence. If you had asked him for a more specific request or say, we cannot meet your request because we don't know, it's too vague, or there are unusual circumstances here because the number of documents requested are too many, or just that we don't understand exactly what it is you're looking for. All I was saying is that I thought Congress in these statutes simply wanted you to tell the man something. Tell him that, that the request was denied, if it's denied, and then the statute goes on to say, tell this gentleman some reason. Therefore, what you've been telling me the reasons. But the point is, the statute says the agency should have told him the reasons, and it should have told him within 20 days. If you look at a request and you can't make heads or tails of the request, fine. An agency has the right to say we can't make a heads or tails, we deny it, and say what the reasons for the denial is. But what I don't see is I don't think you have a right to sit on it for a year and 4 months, and then another 7 months, and then another 6 months, without saying one doggone thing.
Well, I would say they did sit on it way too long, and they sat on it for a year, and they should not have sat on it for a year. But when they did come back in a year, they told him specifically, your request would be
more than a year.
A year and 4 months.
A year and 4 months.
I'm not trying to limit the amount of time.
5 times the statutory, 6 times the statutory limit.
Agreed.
4 months.
It is agreed that it is way longer than the statute provides. But when they did come back to him at that time, they provided him and they said, we will process your request if you pay the $1,640 in search fees. If you put that forward, our DOJ regulations say you must pay for the search fees. He didn't do that. At that point in time, the regulations say no further processing is required. It might have been that they were wrong initially, but Mr. Coleman is wrong as well for not paying the search fees if he wants his request processed. And that's what POLIC stands for. POLIC is the exact same situation.
He didn't know what he was supposed to pay until years after he made his request.
He knew on that when they responded on that date in July 2009, which was well beyond the 20 days, but they knew at that point in time that he advanced payment of $1,640 for processing the request.
But I thought I thought the OIP appeal said that the DEA was incorrect in what they were doing.
Not with respect to that. The
Then
only
why did
thing,
they remand it?
part of the problem here is also the OIP, which allowed this appeal to go forward on an issue that really wasn't relevant as to whether he was commercial or non-commercial, because the only fees that the agency was requesting were search fees. And whether he's commercial or whether he's non-commercial, it doesn't matter. He still has to pay the search fees. And that's ultimately what the district court is getting at, is that it doesn't need to determine what his status is, because he's not willing to pay the $1,640. And so he very well might be a non-commercial requester, but he still hasn't paid the $1,640, and they still haven't improperly withheld the documents because they are allowed to not process the request further until there's the payment of the $1,640. And that's what POLIC says. The exact same thing happened where the agency waited way too long, and the court said 2 wrongs don't make a right. The agency might have waited way too long, but the agency was still entitled to the fees, and that's all that we're saying here. We're not trying to defend what the agency did in terms of timing or anything else on that front. We're just saying he needed to pay.
Of course, POLIC refused to pay any fee at all, and he never requested a waiver. There was no contention there that the disclosure was necessary to public understanding. It was I think the facts were different. I mean, POLIC seemed to me to lie down in the road or lie down in the railroad tracks a lot more than this individual.
Right. Well, ultimately on the public interest waiver, it's, I think, a totally different issue, which is the need to present it to the agency before bringing the case here. And it just wasn't done. And that is an exhaustion issue. The fees issue is separate in the sense of that's the POLIC issue. POLIC says he had to pay those fees. Now, he could have brought a fee waiver request. He had the opportunity to do it. He didn't do it until December 6, 2010. I know my opposing counsel said he raised this on appeal, but in fact, the statement on appeal said, despite being eligible to request a fee waiver, I offered to reimburse the DEA for search and duplication costs up to $1,000. I mean, he clearly didn't take an appeal, and if you need, or didn't request a fee waiver, and if you need any further confirmation of that, he filed an affidavit in the court below saying that he, quote, and this is at page JA 85, Mr. Coleman said under oath, he, quote, had not requested a fee waiver either in his original FOIA request nor in his appeal. I mean, he didn't put it forward.
But, it's somewhat ironic that in this case, the DEA is telling him you didn't do something in time.
It totally is ironic.
It is.
But ultimately, it helps the district court because as the statute specific on the fee waiver says, is that the only thing that the court is allowed to look at is what's in the record before the agency. And ultimately, there's only one sentence.
If we don't, some cases you just have to cut the Gordian knot. And if we don't cut the Gordian knot in a case like this, the signal that we are sending is that an agency can come out with, with innumerable delays and all of this bureaucratic gobbledygook to avoid giving someone a record to which he is, by an act of Congress, entitled. And this man, he shouldn't have to hire counsel to deal with all of these very arcane statutory provisions. You should go out of your way. This person he was not represented by counsel at the time he made his request, was he?
He was not represented, although he's quite knowledgeable about the FOIA requests.
Maybe so, but we can't have a sliding scale of knowledgeability. He was unrepresented. And I don't understand why the agency can't, when they have an unrepresented requester, try to make things easier rather than more difficult by not giving him any answer, tying him up in knots, and, you know, knowing that he's not going to be able to hire a lawyer, because a lawyer, in an attempt to resolve this issue, would cost many, many more thousands of dollars than the difference between $1,000 and a 1748 figure that the agency and the requester are quarreling over. You know you have him over a barrel. He doesn't have a lawyer, and he can't afford to hire a lawyer. So you think you can take your own sweet time in dealing with him.
Ultimately, if the court wants to send a strong message to the agencies that they need to respond, that's fine. I still think we're completely right on the law. I don't disagree with you. They should respond faster and in...
The problem, addressing the problem, and I'm not trying to justify it, but the problem was the way that statute was designed.
Right.
And I gather, basically, it's an agency responsibility to do it in 20 days, but what the Congress said is the sanction is if you don't, you go to court and get it done.
Right.
And the court can do it in 20 days or 21 days. And if time was of the essence, he could do that. The problem for this man, your argument, I gather, is that when they finally did respond, delay wasn't the issue. It was the payment of the 1640. And the 1640 was a gate he had to go through in order to get documents. And he chose not to. And he went to court, and court said he didn't go through that gate.
I think that's exactly sums up our argument.
Well, I'm wondering something more, even more basic, because there are all kinds of issues where delay, there are waivers of agency rights. And I'm wondering, in a situation like this, where the record is so condemnatory of the agency's delays and conduct, whether you waive your right to require a fee. The district court can order those productions of the production of the documents, and that's clear under the statute. But there have been courts, I think, that have said in the face of conduct like this, you waive your right to require the fee.
Well, I think that it would be completely improper here because Congress has actually stepped forward and said, here is how we're going to resolve it in the future. It didn't apply to this particular fee, but going forward, if he were to put a new request in today, he would have that provision that you mentioned, and if they don't respond in 20 days, they can't get search fees. And so Congress has responded here, and I don't think it's...
Well, then why wouldn't that provision that says you're going to be limited to duplication fees, why wouldn't that provision apply?
Because that provision specifically says that it only applies to information requests after a year after the enactment of the statute, which is, after the requested issue here.
But at some point, there has to be a waiver. An agency has to waive its right to a fee if the conduct just doesn't pass the straight face test.
Well, I mean, I don't think that, as bad as the conduct you may describe here, the Paula case involves almost the exact same delays, and yes, he didn't ever ask for a fee waiver anywhere. He said he wasn't going to pay any fees, but it's no different. He was actually asking exactly what Your Honor is proposing here, is that, well, the agency can't charge me any fees because of the excessive delay.
We now
and the
have a
court said,
statutory provision which would waive the search fees.
it would going forward, but again, Congress was quite explicit as to the starting date of what requests it would apply to, and it doesn't apply here, and they haven't argued. I assume that's why they haven't argued it here, because Congress was very clear as to which request for information it applied to, and it was after this date. But going forward, I do think that will help agencies push them for whatever additional incentive they need to act quickly.
Well, it's still a very minor sanction to just say, oh, well, they're not going to go to court, and even if they do go to court, all we're doing is waiving the search fees. And, I mean, all that we may have to do is waive our right to a search fee.
I mean, ultimately, that you might be right, but that's for Congress to decide what to do.
But you're talking to me about what Congress wanted. You know, Congress was the one, not me, that put that 20-day deadline in and put the district court authority in. If we want to get into what Congress intended, they surely intended nothing like this.
Agreed. But ultimately, once the agency did act, even if it was too slow, they had the right to the fees. And when
why the 1640 number when the search costs were 17-something?
I believe it has to do with you get 2 free hours of search, and so that was the total amount.
Okay, thank you, Mr. Moskowitz. Let's hear from Mr. Stoddard.
Thank you, Your Honors. I would like to make 3 brief points that directly address the questions that were presented to my able opposing counsel. First is as to the legal right. This is a situation where the legal right under constructive exhaustion actually occurred in one of the later stages that Judge Wilkinson referred to. When the DOJ issued its decision on March 29th, 2010, and it sent the request back to the DEA. At that point, they received the request. They received it from the DOJ, and the 20 working days applied there, and there wasn't anything that Mr. Coleman could appeal. He was waiting for a decision. So as a matter of law, what distinguishes this case from Oglesby or Pollock or any of those other cases is this is not a case where he did appeal initially. He got a decision and he won the appeal. It was sent back to the agency, and the agency gets the request, and then he was entitled to a decision within 20 working days, and he had nothing to appeal. So as a matter of law, this was a case where constructive exhaustion hits the nail, and he had a right to go to court. So,
well, he had a right to appeal the question raised, which was whether he was commercial or non-commercial.
He did raise that.
The government's, and the district court could have been required to decide that in this case because there's exhaustion.
That's right, they should have.
Right. The government's position is, I gather, is that the search, that issue is irrelevant to the search fees which apply regardless.
That's exactly my second point, the prepayment issue.
Yeah, and the prepayment of the search allows the agency to not go forward until they get the money.
That's exactly the second point I was going to raise, the prepayment issue. The prepayment issue is this. If you are ordering food at a restaurant, you know the price that you're going to pay, the total price. You have a menu. This gentleman had a right to know which fee category he was going to be in because, frankly, he could decide I'm not even going to go forward with the request. If I go to a restaurant that's the menu's too expensive, I can say I will not order an hors d'oeuvre. I will not order dinner. And the point is, he had a right to get a decision of which fee category he was in to decide, do I go forward at all? And I think that preliminary question would have dictated whether he did go forward or not. And related to all of the questions from counsel as to narrowing this process, let me say that Mr. Coleman did offer to narrow, and I will affirmatively say if this case is...
Well, it seems to me if your hypothetical is right, if that's, or not hypothetical, if your argument is correct, then his sanction is 20 days after the remand, go to district court and get that order. The sanction that Congress provided isn't punishment for delay. I mean, the government is an operation that no one person controls.
Go to court.
Is go to court.
You're exactly right. That's what he thought.
Go to court and go back.
That.
But the agency still is justified, it seems to me, to say we're not going to start until we get prepayment.
That's right. And he is not arguing that he doesn't have to pay, and he's not arguing that he has to get the records first. All he wants is a settlement of which category he is under before he gives a blank check to not even knowing which fee category he would fit under. Let me say this. If this case is remanded, number one, there's no question that Mr. Coleman is prepared to work with the agency because he thinks they do not understand his request in a way that significantly could narrow the request. Number two, he's offered in his in his letter of April 22nd, which is in the record at 42, he's offered to help narrow the process by doing what's called the reading room review, where he goes through the records and says, I want item A, I want item B. It saves a ton of agency time. It saves a ton of agency costs. So Mr. Coleman is absolutely willing to narrow this request. The problem is he never got the chance. And the reason he never got the chance is because A, the agency on remand dropped the ball and he constructively exhausted it, and B, the district court respectfully dropped the ball by saying we're not going to cut to the chase, we're not going to resolve the fee issues and let this move on to the next stage, because it would have led to if they gave a price tag that was too high, it would have led to a natural tendency, a win-win, whereby he would say, I only want this and that, and they say, sure, that's only going to cost $500, and everybody wins. The problem is when the district court says we're going to throw the case out after he's constructively exhausted, and that's why he's here, Your Honor.
I think we understand your argument.
Okay, if I have one last point, I would just like to say this. If I see that I have 2 minutes, I just would like to say that with regard to the public interest fee waiver, I appreciate the comments of my able opposing counsel that there was a limited raising of that issue before the case was filed. But the thing that is important to recognize is that the DEA issued a decision specifically talking about the public interest fee waiver in Exhibit G, which is their November 22nd, 2010 response. And then thereafter, Mr. Coleman filed on December 6, 2010, a document that exhaustively walked through the public interest fee waiver factors.
Already in court, though, by then.
So the question presented is, if the agency is allowed to respond after the court case is filed, does it not follow that the requester has the same? The administrative remedy, the administrative process is effectively still going on, just subject to the court's judicial oversight. And so I would argue that those documents, if they're allowed in, it has to be either both of them are out or both of them are in. It does not follow that one of them can come in, the agency's response, and not Mr. Coleman's detailed letter saying why he should get a public interest fee waiver. Thank you, Your Honors.
All right, we'll come down and greet counsel, then go into our last case.